GAs, the volume of business oftentimes is such that there's pressure to move the cases and perhaps to dispose of cases. And there must be, from my observation, I sometimes get the impression that there is the potential danger or tendency not to do as you said in your comments, that is to take every case on a case-by-case basis. But because of the crush of business and perhaps the pressure to move cases, there may be this tendency to adopt the belief that the five guys, young black males or young Puerto Rican males that came before me are as bad actors as could possibly be, so the sixth one is probably the same. And for those of you who don't succumb to that kind of pressure, I certainly congratulate you and commend you. But I think it's probably very human, given the conditions and the volume of business in the GA, that is a possible danger. And I guess not looking for any response from you, but for you and all of the other judges that may come before us today and on future dates, just given some of the frailties of the system, I just want to encourage as much as possible to resist the temptation to succumb to just not giving every single defendant in every single case the consideration and the thoughtfulness and the treatment that it deserves. The other thing that I wanted to maybe get some reaction from you on is every now and then we get some real life evidence of the shortcomings of the system. The system's not perfect. I happen to think it's one of the best systems in the world, but it's definitely not perfect. And unfortunately, we see cases like probably the most notorious one, the Tillman case, where maybe the system made an egregious mistake or a mistake that is very adverse, at least to that one individual. It sort of highlights that we can make mistakes. The system can make mistakes. Given that, I've become somewhat familiar with the tendency in some of the courts, and again, it may apply to judicial districts, but particularly in GAs, where a defendant opts to go to trial and is found guilty at the conclusion of a jury trial. It seems like the sentences at that point are more severe than they would be if there was some plea negotiation that the state and the parties reached prior to trial. Can you give me some comfort in an explanation of or justification for that kind of method? And I guess what I'm worried about is it seems to me to be disadvantageous to the defendant, and it seems to me to be penalizing the defendant for the exercise of a constitutional right. And I'm sure that you or others may have some justification for this system. I'd like for you to share it to me, because I would like to derive some comfort that there is some good rationale for this particular kind of approach.
Our Supreme Court says that there's a benefit to a defendant who pleads guilty early on in the criminal justice process. I'll give you one example of a case in New Haven where an individual in the East Rock section, which is close to Hamden, and this individual was raping young women as they jogged along. And there may have been, I don't know, 5 or 6 victims involved. And the case was plea bargained before the presiding judge in New Haven. It wasn't myself at the time. And I believe the sentence was 25 years, something like that. And it had to do with 5 or 6 sexual assaults in the first degree. The person then moved to withdraw his plea, and the judge denied it. The appellate court said the trial judge had missed a few salient points in the canvas and allowed the plea to be withdrawn. The person then went to trial in New Haven. After conviction, got 90 or 95 years. That person took an appeal to the federal court saying that I had a plea bargain for 25, now I was penalized because I went to trial. And the federal judge at that sentencing or on the appeal said that the sentence was proper because each of those assault victims had to come to court and testify and be subjected to cross-examination. And each one was on the stand for, say, 3, 4, 5 hours with direct and cross-exam. Their entire life was opened up to cross-examination, their mental health, everything. So why should a person get the same deal they could have had when the victims were not open to the public? Their rights of privacy were not opened up. They didn't have to live through that horror again. So that's why you see the disparity in the sentences, sir.
And that's a good explanation. Your example is a hard one to argue against. I guess what I'm more concerned about would be the case where a defendant has no prior record. There may be allegations of a bad stop, bad arrest. There may be every good reason to go to trial. And at the conclusion of a trial, defendant with no prior record gets found guilty. Does that defendant necessarily deserve an enhanced kind of sentence?
No.
Okay.
Just like we have violations of probation, I pre-try those. If I tell the lawyers, if you can't work it out between yourselves, I'll do the hearing. If the violation of probation is a baloney violation of probation, I don't give the person what they owe. If they owe 6 years because they had a hearing, do I give them 6 years? No. You give them the fair sentence based upon the violation. So the set of facts you gave me, a person has no record, questionable stop here or there, goes to trial, the maximum penalty is 20 years. You're going to give them 20 years? No. I don't think any judge in Connecticut would.
If it is a jury trial, and at conclusion of a jury trial, there's a guilty verdict.
Yes,
Same facts. Defendant has no prior record. Does that defendant necessarily merit incarceration?
Depends upon the facts of the case. If the facts of the case don't warrant it, no. But the problem that comes in sometimes, a person can be charged with a crime that carries a mandatory sentence. Now, at the time of plea bargaining, let's just say it was a burglary in the second degree, Class C felony. If you're armed with an explosive or whatever, it carries a mandatory 5 years in jail. The state may think they have problems with the case. They'll give you a burglary 2 on the non-mandatory section for 3 years in jail. You don't take it, you go to trial. The state's attorney is going to try the case on the mandatory subsection. That's his or her right. If convicted on that, you're going to get at least the mandatory 5 years in jail. But if it's a non-mandatory charge, based upon your factual scenario, no violence involved, the person should not go to jail. But again, it's hard to make that statement in a vacuum. If it's a residential burglar, breaks into a house, and a woman and her small children are home, and he has no prior record, he's convicted after a jury trial, and the burglary took place at 2 o'clock in the morning, should that person go to jail? I think he should. But again, depending upon the time, I don't know.
And finally, I think I've detected another situation of somewhat concern to me. In Hartford and in New Haven, I think the police units or the police departments have adopted anti-gang activity units. engaged in crime suppression, I suppose. And the police behavior seems to be very aggressive. And again, maybe there are judgments that are being made that identify individuals as affiliated with gangs. But it's almost as if it's sort of analogous to some of the criticism that we get subjected to as a government in our response to terrorism, and that is we're infringing upon people's rights, and perhaps the ends do justify the means. But at the local levels, in the urban centers where there may be a lot of young people involved in maybe gang activity or drug activity, it seems like there may be some tendency on the part of law enforcement officers to cut corners and to maybe be a little bit overzealous, over-aggressive in stopping people and arresting people. And I'm trying to determine if my assumption or if my observation is correct, what protection, particularly as a criminal defense lawyer, can I bring to bear for people who may get caught up in this net? I think part of the system assumes that the prosecutors are always reasonable, and particularly in the scenario where we're talking about what happens at the conclusion of a trial. I think in many cases the presumption is that it's the defendant that's being unreasonable, and that the state's attorneys are never unreasonable in the offers that they make. And
Now, that's not true. We know that.
Okay. Well, I guess what I'm trying to get at is, I think everybody wishes that there weren't drive-by shootings, that there weren't drug deals, that there weren't gang activities. Everybody, including me, wishes that that was the case. The concern that I'm trying to express, I guess, is if there is an over-response on the part of law enforcement agencies, what do you do as a defense attorney to provide the protection to the person that gets caught up in that kind of law enforcement activity, and but perhaps doesn't merit being lumped together in that?
Well, see, if you had brought a motion to suppress or whatever, and it's heard by a judge, and if in fact these facts come out that the police are using the end to justify the means, the judge who hears that particular motion would then contact the state's attorney to contact the chief of police to see exactly what's going on. And if that's what's going on in this one instant and others, to tell the police to stop it. I mean, if you bring it to the court's attention and it's shown in court that that is in fact happening, the judge has the responsibility not to talk to the prosecutor who's doing it, but to talk to the state's attorney for that district, who really is the chief law enforcement officer for that district, Mr. Darrington in New Haven, Ms. Hardy in Hartford. And they should then sit down with the chief of that respective police department to deal with it, to make sure it's not happening on a widespread scale, and if it is happening, to stop it.
And I appreciate that response. I suppose that's probably the only response that you could give. But what you're saying, I'm sure you realize, is easier said than to actually put into practice.
Well, if in fact the abuse is shown to the court and the judge speaks to the state's attorney, then it's going to have to be put in practice, because if it's not, then the judge, I mean, I'm kind of an active kind of person, would get involved with the chief and the state's attorney, because everyone has a right to their life, liberty, and pursuit of happiness, to go about their own business, to enjoy all the freedoms our forefathers fought for. So I know it's easy, but it's got to be shown to the judge that the abuse is actually
That's where the
taking
problem
place.
comes in.
I know that.
There's a certain amount of credibility that will attach to a police officer, And when a police officer writes a report, perhaps you as a judge or anyone else as a judge will give a certain amount of credibility and legitimacy to the report that's written.
Yes, you're right.
And so I guess the burden upon the defendant to show that he is being harassed or that there are certain liberties that were infringed upon becomes tremendous, if not impossible.
That's a possibility, yes, sir.
Okay.
I don't have an answer for that, I'm sorry.
Yeah. In any event, one last concern. I know I said that was my final one, but Senator Kissel, in some of his earlier comments to another nominee, made an effort to drag me upon a soapbox that he was speaking from. So I'll get there. We were talking, or he was talking and engaged in dialogue about how perhaps different communities treat the same kinds of offenses. And as he was saying that, I was thinking about an experience that I had. I was a student in the New Haven public school system when I was growing up. Even at that time, the schools that I went to were predominantly black. Was fortunate enough to win a scholarship to a prep school, New England prep school, where the student population was predominantly white. There are, from my experience and observation, there were very little differences as far as concerns the character of the students in either system. Those that were inclined to test authority may have used alcohol, may have used drugs in both school systems, in the predominantly white one and the predominantly black one. In the predominantly black one, though, if there was a fight, there was zero tolerance, even back then. If there was alcohol use, zero tolerance. Drug use, certainly zero tolerance. In the white school system, things were sort of dealt with in an insulated manner, and reports were never made to police. Could have been the very same kinds of drug abuse, alcohol abuse, or fight that took place in the New Haven school system. But were never reported, never reached any kind of law enforcement agent or agency. And so I guess that, for me, sort of opened my eyes to the beginnings of the disparities that exist in the system, because you'll have an individual student in the New Haven public system who may, as a result of being reported by that school system, all of a sudden end up with a record, and the implication of that record with future contacts with the criminal justice system. But you'll have an individual in another community engaged in the same kinds of activities, doesn't end up with a record, no implications as far as future employment is concerned, or if there is a future contact with the criminal justice system, there will be no judge looking at a prior record and making a determination based upon the existence of that prior record. So again, I guess not looking for any response, just trying to share my concerns that there are disparities in the system which unfortunately have greater implications for some as opposed to others. So thank you for your time and your attention to my concerns.
Thank you,
and,
sir.
I wish you luck going forward.
Thank you very much.
Mm-hmm.
Are there any other questions? Thank you very much.
Thank you very much, Senator.
Next is the Honorable Christine E. Keller of Hartford, followed by Judge Norco. Good afternoon, Your Honor. please raise your right hand.